Hello students, today we'll talk about enforced disappearance. Enforced disappearance is a phenomenon that produces anguish, fear and sorrow for thousands of families. In the past, only military dictators were known for this practice, but now it is being employed even in the democratic countries in situations of declared and undeclared armed conflict. The report of the working group on the enforced disappearance stated that this practice continues even today and has ramified in around 60 countries. In 1979, a resolution was adopted by United Nations General Assembly entitled Disappeared Persons. Prior to this, such persons were referred to as missing persons or persons unaccounted for. In India, enforced disappearance have taken place in the northeast states like Nagaland, Mizoram, Manipur, Assam, etc. Punjab and Jammu Kashmir has also witnessed the cases of enforced disappearance. Now let me talk about first the definition of enforced disappearance. Article 2 of the International Convention for the Protection of All Persons from Enforced Disappearance define enforced disappearance as the arrest, detention, abduction or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with authorization, support or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the whereabouts of the disappeared persons, which places such person outside the protection of the law. Inter-American Convention on Forced Disappearance of Persons define forced disappearance to be the act of depriving a person of his freedom in whatever way perpetrated by agents of the state or by persons acting with the authorization, support or acquiescence of the state, followed by an absence of information or a refusal to acknowledge that deprivation of freedom, thereby impeding his recourse to the legal remedies and procedural guarantees. Now let me explain you what are the essential ingredients of the act of enforced disappearance. The arrest, detention, abduction or any other form of deprivation of liberty. Then by agents of the state or by persons acting with the authorization, support or acquiescence of a state. Refusal to acknowledge the deprivation of liberty or concealment of whereabouts of the disappeared person. Lastly, such refusal places the person outside the protection of law. Now let me explain you what are the probable reasons of enforced disappearance. Special counter-insurgency laws such as the Armed Forces Punjab and Chandigarh Special Power Act of 1983, Terrorist and Disruptive Activities Prevention Act of 1987 (TADA) gave security forces greater power to arrest, detain and kill suspected militants and provided immunity from prosecution to officers who acted in pursuance of these special laws. The impunity laws is a major factor behind the cases of enforced disappearance. In a typical scenario, a police take into custody a suspected militant or militant supporter without filing an arrest report. If the detainee dies during interrogation or is executed, officials deny he was ever in custody. It is claimed that he died during an armed encounters with police or security forces. Sometimes, police claims to have been ambushed by militants while escorting a suspect, which resulted in exchange of fire, hence the death of the person. The Indian society is a mixture of different races, religion, caste, gender, and so on. There are certain weaker sections of the society who are exposed to the possibility of being attacked or harmed because of their socio-economic conditions. At times, people are exposed to attack because of the fact that they belong to a particular caste or community. They do not have access to full protection of human rights. Members of vulnerable class are sometimes labeled terrorists and killed, although later it becomes clear that they were innocent. The low social status of these persons hamper their access to justice and redress mechanisms. There is no independent agency in India which can effectively investigate crimes committed by law enforcing agencies. These lacunas in the existing criminal justice system are misused by the police or security forces. Sometimes law enforcement agencies fail to solve the criminal case or the criminal becomes difficult to handle. Then the police, instead of bringing them to justice, decides to eliminate the criminal. Now let's talk about various international instruments in the context of enforced disappearance. The 1992 Declaration on the Protection of All Persons from Enforced Disappearance provides in its various articles that all acts of enforced disappearance shall be offence under criminal law, punishable by appropriate penalties. The penalty shall take into account their extreme seriousness. However, if a person who has participated in the enforced disappearance becomes instrumental in bringing the victim forward alive or provides crucial information which would contribute to solving the case of enforced disappearance, it may be considered as a mitigating circumstances in deciding the punishment to such persons. Statutes of limitations, where they exist, relating to acts of enforced disappearance shall be substantial and commensurate with the extreme seriousness of the offence. Persons who have committed offences of enforced disappearance shall not benefit from any special amnesty law or similar measures that might have the effect of exempting them from any criminal proceedings or sanction. In the exercise of the right of pardon, the extreme seriousness of acts of enforced disappearance shall be taken into account. The victims of acts of enforced disappearance and their family shall obtain redress and shall have the right to adequate compensation, including the means for a complete rehabilitation as far as possible. In the event of the death of the victim as a result of the act of enforced disappearance, their dependents shall also be entitled to compensation. The 1994 Inter-American Convention on Forced Disappearance of Persons provides in its various articles that the act constituting the forced disappearance of persons is an offence. The person who participated in enforced disappearance when they help to cause the victim to reappear alive or provide information in the context of enforced disappearance of a person will be entitled to the benefit of mitigating circumstances. Criminal prosecution of a person for the act of forced disappearance of persons and the penalty judicially imposed on its perpetrator shall not be subject to statutes of limitation. The 2006 International Convention for the Protection of All Persons from Enforced Disappearance provides in its various articles where there are reasonable grounds for believing that a person has been subjected to enforced disappearance, the authorities shall undertake an investigation, even if there has been no formal complaint. No one shall be held in secret detention, and any person deprived of liberty is authorized to communicate with and be visited by his or her family, counsel, or any other person of his or her choice, subject only to the conditions established by law. International Covenant on Civil and Political Rights has also provided the right to liberty and security of a person. No one shall be deprived of his liberty except on such grounds and in accordance with such procedures as are established by law. Each state shall ensure that the person whose rights or freedom are violated has an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. Now let's talk about the remedies against enforced disappearance in India. Article 32 of the Constitution, forming part of the guaranteed fundamental rights, empower any person aggrieved by any action on the ground that it violates his fundamental rights to move the Supreme Court under Article 32 or any of the High Courts under Article 226. A writ of habeas corpus can be filed either in the Supreme Court under Article 32 or in the High Court under Article 226 against the forced disappearance of a person as it results in the violation of the right to life and liberty, guaranteed by Article 21 of the Constitution. In the case of enforced disappearance, generally the restoration of a personal liberty is normally not possible because of the irreversible nature of the harm suffered, so monetary compensation to some extent can help in rehabilitation of the dependents of the victim. Petitions before the National Human Rights Commission can be filed for the violation of human rights. The National Human Rights Commission is empowered to investigate forced disappearance under Section 18 of the Protection of Human Rights Act. The National Human Rights Commission has the power to investigate the matter of enforced disappearance and recommend monetary compensation to the victims of human rights violation. The Commission is also empowered to initiate proceedings for the prosecution of the guilty public officials. The award of compensation in the public jurisdiction is also without prejudice to any other action like civil suit for damage which is lawfully available to the victim or the heirs of the deceased victim, with respect to the same matter for the tortious liability committed by the functionaries of the state. Now let's talk about judicial response against enforced disappearance. In Budheshwar Bora versus State of Assam and others, police party during the course of anti-insurgency operation picked up one Srimati Moni Bora, aged about 30 years, in the presence of the local villagers, and since then she remained untraced. The petitioner invoked the extraordinary jurisdiction of the court under Article 226 of the Constitution of India with a prayer to issue a writ in the nature of habeas corpus, directing the respondents to produce the detainee Srimati Moni Bora. The court found it to be a violation of Article 21. It held the violation of the Article 21 to be patent and of a magnitude that shocks the conscience of the court, and accordingly awarded compensation of rupees 2 lakh payable by the state to be recovered from the officers responsible for causing disappearance of Srimati Moni Bora. It also expected the state to hold an appropriate inquiry into the matter. In Sebastian M. Hungary versus Union of India and others, the petitioners asked for a writ of habeas corpus under Article 32 of the Constitution to be issued to the respondents to produce two persons, Colonel Daniel and C. Paul, in the court, who according to the petitioner were illegally taken away by the army Jawans and unauthorizedly detained by the officers in charge of 21st Sikh Regiment, whose whereabouts were not made known. The Supreme Court considered it prima facie an offence of murder and directed the police investigation to identify the perpetrator of the crime for their disappearance. Exemplary cost was also awarded to the wife of the victim for undergoing torture, agony, and mental oppression due to her husband's forced disappearance. Now we can conclude and say that enforced disappearance is a widespread phenomenon that involves extreme suffering for the victims. The plethora of reported cases reveal that cruelty is involved. The value of life and sense of basic human decency are all undermined. Prohibition of enforced disappearance allows no exception. Despite serious developments on the international level, such as the adoption of the 1992 Declaration and the progressive evolution of jurisprudence, there are still unsolved issues which hinders a satisfactory response to the phenomenon. Provisions for legal immunity for the offence of disappearance are embedded in the criminal justice system in the form of official barriers, such as requirement of prior sanction from the authority for legal prosecution of security personnel. Such a culture of impunity has made the practice endemic in India. Even the Supreme Court of India has failed to address the ongoing disappearances by turning down challenges to the legality of the laws under the region. The current legal system will remain unable to wipe out the practice of disappearances. The government has not acknowledged the seriousness of the phenomenon of disappearance, so it has not addressed the issue properly. There is a need to define enforced disappearance as a crime in the penal law of India and foster means of prosecuting the guilty and providing adequate compensation to the affected families.